All right, let's dive right in. We're talking about one of the most important pieces of the Indian Constitution today, Article 19. It's often called the bedrock of our democratic freedoms. But, and this is a big but, it comes with a pretty significant asterisk. So think about it like this. What if someone handed you the keys to an amazing new car, but then you open the glove box and there's this huge manual full of rules and fine print telling you where you can't go and when you can't drive? That's kind of what we're getting into here. What if your most fundamental freedoms came with conditions? Okay, so let's break it down. Article 19 is basically a freedom with responsibility package. It's a two-sided deal. On one side, you get this amazing list of 6 core freedoms, the stuff that really makes a democracy tick. But on the other side, the state gets to impose what it calls reasonable restrictions. And that balance, that tension right there, that's everything. All right, so first up, let's look at the good stuff. What are these 6 core freedoms we're talking about? And here they are. First, you've got the freedom of speech and expression, to say what you think. Then, the right to assemble peacefully, without weapons, of course. You can form associations, like unions or clubs. You have the right to move around freely anywhere in India, and also to live and settle wherever you want. And finally, you can practice any profession, trade, or business you choose. I mean, these are literally the pillars of what it means to live in a free society. Okay, but remember that asterisk I mentioned, the fine print? Well, this is it. This is where things get complicated. For every single one of those freedoms we just listed, the Constitution says, hold on a second, and introduces this idea of reasonable restrictions. And this really shows you how it works. It's like a 2-column ledger. On the left, you've got your freedom. On the right, you have the reasons the government can limit it. So freedom of speech, well, that can be restricted in the interest of, say, the security of the state or public order. The right to assemble? Same deal. Every single right has a corresponding set of potential limitations written right into the Constitution. It's this constant, delicate balancing act. Now, you're probably thinking, words like reasonable or public order sound, well, pretty vague, right? Who decides what's reasonable? And that's the million-dollar question. The answer is, the line gets drawn in the courtroom. So let's jump into some of the huge, landmark legal battles that have defined what Article 19 really means in practice. We're starting way back in 1950, just as the new Constitution of India was getting its legs. This first case is a classic. It's about a banned newspaper, a defiant publisher, and a question that goes to the very heart of what free speech is all about. Okay, so here's the setup. There was this English weekly called Crossroad, published out of Bombay. The government, in what was then Madras, decided they didn't like what it was printing, so they just banned it. Completely banned its circulation, saying it was a threat to public order. The publisher, a guy named Ramesh Stapper, wasn't having it, and he took the case all the way to the top. And this forced the Supreme Court to ask a really fundamental question. Is freedom of speech just about the act of printing something, or does it also protect your right to actually get it into people's hands, to circulate your ideas? The court's response was, well, crystal clear. This quote from Justice Patanjali Sastry really nails it. He basically said, hey, what good is the freedom to publish if you can't circulate it? I mean, it's common sense, right? A publication has no value if nobody can read it. The court made it official. Circulation is an essential, non-negotiable part of free expression. So this case gave us 2 huge takeaways. First, and most obviously, freedom of expression includes freedom of circulation. They're 2 sides of the same coin. But second, and this was a game changer, the court raised the bar for what counts as a reasonable restriction. It said you can't just ban something because you're worried about public order. No, the threat has to be much more serious. It has to be something that could undermine the security of the state itself. We're talking about things that could lead to rebellion or war. This was a massive, massive victory for the free press. Believe it or not, in that same year, 1950, another major case involving press freedom landed in the Supreme Court. But this one was different. It wasn't about banning something that was already published. It was about censorship before a single word even made it to the printing press. So what happened was, the government told a weekly magazine called The Organizer that from now on, they had to submit everything, every article, every cartoon, all of it, to a government official for approval before they could publish. This is exactly what's known as pre-censorship or prior restraint. So the question before the court was pretty straightforward, but its implications were huge. Is it constitutional for the government to essentially act as the editor for a newspaper? Can they demand a pre-screening of content and decide what the public gets to read? And once again, the court came back with a resounding no. They stated very clearly that imposing pre-censorship is a direct restriction on the liberty of the press, and the liberty of the press is a crucial part of the freedom of speech and expression. And just like that, another foundational legal principle was set in stone. Pre-censorship is unconstitutional, full stop. The state simply cannot demand to approve content before it's published. If there's a problem, they have to deal with it after the fact, based on what was actually said. So it's useful to look at these two cases together. You have Ramesh Thapar, which dealt with a post-publication ban on circulation, and then you have Brij Bhushan, which dealt with a pre-publication censorship order. Think about it. Together, these two rulings from 1950 created this powerful shield for the press, protecting it both before and after the ink hits the page. Okay, but what about other kinds of speech? I mean, is a commercial for a face cream the same as a political opinion piece? That's a question the Hamdar Duhana case got into. Does commercial advertising get the same protection? And the court said, not exactly. They basically drew a line in the sand. They ruled that when it comes to things like false medical claims or ads for dangerous products, the government absolutely has the power to restrict that kind of commercial speech to protect public health. Let's switch gears for a second to a different freedom, the right to move freely. We know Article 19 guarantees that within India. But what about traveling abroad? The famous Maneka Gandhi case pushed this very boundary. And the court's finding here was really interesting and nuanced. They said, look, the right to travel abroad isn't explicitly part of Article 19's freedoms. However, if the government is going to restrict it, the procedure they use has to be fair, just, and reasonable under another article, Article 21. It's a great example of how different parts of the Constitution work together to protect our liberties. So we've seen the rights, we've seen the restrictions, and we've seen how the courts have fought over the details. It all comes back to this one central idea. All right, let's wrap this up with the key takeaways. What do you absolutely need to remember? Number one, these freedoms are fundamental, but they are not absolute. There are limits. Number two, any restriction the state imposes has to be lawful and, that key word again, reasonable. Number three, freedom of speech means nothing without freedom of circulation, and pre-censorship is a definite no-go. And finally, not all speech is created equal in the eyes of the law. Commercial speech, for instance, has less protection. And that brings us to today. You know, all these landmark principles were forged in a world of printing presses and newspapers. But now, we live in an age of social media, viral content, and instant global communication. It makes you wonder, that debate over what's a reasonable restriction is more complicated and more urgent than ever. So I'll leave you with this question. In our world today, where do we draw that line?